We are here today in both cases on an initial permanency hearing. We are conducting this through Zoom under a finding of good cause and agreement of the parties, and we are live streaming. Ms. Bayless is making our record this morning. Okay, we'll go ahead and take announcements.
Daniel Trout for the Texas Department of Family and Protective Services. Erica Cantrell, my permanency specialist. We're present and ready.
Savannah Kincaid, I represent Ms. Pineda. We're both present and ready.
Joel Jackson on behalf of Neil Solis. I'm present. Your Honor, I'm going to announce not ready this morning. The court had signed off on an order for Mr. Solis to appear. He's at the WIN unit in TDCJ. They just recently transferred him. We got your order to the unit. They called us this morning. They're having to power, according to them, the prison's having to power their prison down for a period of 3 hours, and all the inmates are required to be in their cells. And he's not eligible to be present this morning. Therefore, I'm asking for a continuance.
All right, I'll address that in a minute.
Yes, ma'am.
Lori Lucero on behalf of the father Taurus Richardson, Your Honor. I'm present, ready. I don't believe Mr. Richardson will be present.
Stacy Zavala on behalf of the kids, and I would ask that we go off of YouTube today. Annalisa is with us, and I anticipate we may be discussing some private issues regarding the kids.
Okay, let me take up Mr. Jackson's request. Mr. Jackson, just due to the fact that this is just an initial permanency hearing, I'm going to go ahead and deny the continuance. You know, as you know, we're under real strict time guidelines on these hearings. So since it is just the initial permanency hearing, we're going to go ahead and proceed, and then hopefully we can get Mr. Solis present for our next hearing. All right, then, any objection to going off YouTube since the child is present?
No objection, Your Honor.
No objection.
Make a decision on that, and then we'll see where we're at. Okay. Okay, we'll take announcements.
Daniel Trout for the Texas Department of Family and Protective Services. We're present, ready, Your Honor.
Savannah Kincaid, I represent Kirsten Smith. I'm present. She is not present. I've not had contact with her since after our last hearing.
Lori Lucero on behalf of Dylan Green, the father, Your Honor. We're both present and ready.
Stacy Zavala on behalf of Serenity.
Okay. All right, Mr. Trout, I think you had at least indicated the department and everybody had agreed to an extension in the case.
Yes, ma'am.
I had, I think, requested to see if we could get Mr. Green drug screened.
Yes, ma'am.
Do we have any luck getting that done?
We did, Your Honor, and his screen came back. I believe it was filed with the court around the 4th or 5th. It did come back negative on another UA.
Okay.
And Mr. Green has, the reason for the request for the extension was Mr. Green is, since he got out of ISF in September, October, has done very well on working the services. I've been told that he has, I believe, 2 more parenting classes, I believe it was, and he will be done with the services. He's still working through some stuff with his probation. I think he's in BIP right now. Of course, we know that BIP takes a long time, but he is working through that also. There's a few other things. My understanding, he doesn't have a driver's license right now. We'd like to try to get that worked in and start building up to working toward the reunification. I was advised just a second ago, there was some, I don't know if Ms. Lucero asked for it or somebody, but maybe some extra counseling sessions due to something that happened in his counseling. So, but other than that, he's got 2 parenting classes and should be through our services, Your Honor.
Now, is BIP for us or for probation?
That's for probation.
Okay. Okay. All right. So, Mr. Green, I will tell you that, I mean, I'm impressed with the progress that you have made since your release. I was a little concerned when I saw that there was a negative dilute drug screen given. That's why I asked for you to go drug test again. So I'm happy that that was negative, and so based on that, And as far as the progress you're making, otherwise, I will find that extraordinary circumstances exist, and I will grant you the 6-month extension in the case so that you can get things completed and we can work on some of these other issues that, we really need to try to deal with as far as reunification with you and the child. So, Ms. Trout, have you figured out what a new dismissal date would be?
I do, Your Honor. New dismissal would be October 11th of 24.
Okay.
And Your Honor, could we let Ms. Denicky go? I wasn't sure if I needed her here today, but since we're getting an extension, I don't need her today. If we could let her go.
I have no problem with that, Ms. Denicky. Thank you for logging in and have a good rest of your day.
Thank you.
Thank you, Ms. Denicky.
Okay, so we got 6 more months, so let's have a quick review hearing and see, other than what you've just told me, is there anything else really new, Ms. Williams?
No, ma'am. I spoke to Kirsten last week, but she doesn't have a phone, couldn't tell me what hotel she was living in. I caught her at Faith City Mission, so don't have any update on her, but Dylan's doing great and Serenity has made a ton of progress in the last few months as well.
Okay, great. I was just looking real quickly. Okay, yeah, we've already adjudicated Mr. Green. That's what I was just double checking. So we've already
Yes,
done that. Okay. All right, then, Ms. Kincaid, anything today?
Sorry, no, Your Honor. I spoke with Kirsten after our last hearing, but I haven't been able to make contact since then. And if she doesn't have a phone, then it'll be an issue. She has access to our app and she can contact me any way she wants, but I haven't been able to reach her.
Okay. All right, Ms. Lucero.
I just have a couple of questions just to clarify with Ms. Williams. Ms. Williams, you and I had discussed possibly Dylan doing or attending at least 6 more counseling sessions. Is that correct?
Yes.
Okay, and was that based on just the concerns that he had with maybe possibly miscommunication with his prior counselor, Mr. Corby Grimes?
Yes.
Okay, and since you and I spoke, have you been able to locate a new counselor for Mr. Green?
Not a specific one, but
Okay. But once you get that set up, then y'all can send over payment and he can start that up. Is that right?
yes.
Okay, and you'll let him know?
Yes.
Okay. Now, as far as his visits with Serenity, how often is Dylan visiting Serenity?
Once a week for 2 hours.
Okay. Is it possible, if he continues to do well, to increase those visits?
Yes.
Okay. And could you maybe give me an approximation while Dylan's here also, how that would work? What would need to be done for him to have his increased visits?
Finishing these last 2 parenting classes would complete his initial service plan without the extra 6 counseling sessions. So once his parenting class is complete, I can take that to my supervisor and program director and up the time of those visits.
Okay. And is it your understanding that currently he doesn't have a driver's license yet?
Yes.
Okay. Now, once he finishes his initial family service plan and his visits increase, would the department consider, possibly moving into like unsupervised visits since the goal at this time is reunification?
I believe so.
Now, since he's requested or through me these additional 6 sessions with the new counselor, is that going to be deemed? Will that be a negative? I know that we requested him just to clear up some things, maybe some concerns the department would have with his prior counseling. But with that request, that's not going to delay him moving into possibly additional visits or unsupervised visits, will it?
Not that I know of.
Okay. All right, then. I'll pass the witness, Your Honor.
All right. Ms. Ball?
Ms. Williams, has Mr. Green's living situation changed now? Has he now moved in with a girlfriend?
Yes.
Okay. Is she cooperating with you in terms of anything you might need from her?
Yes, at this time.
Okay, and if we're working towards reunification and he's now in the home with her, she would need to cooperate in that process as we move forward, correct?
Yes.
Okay. Has she been asked to drug screen at any point, or is there any need for that?
Not right now.
And in addition to regular visits, Dylan has the ability to attend Serenity's therapy appointments, correct?
Yes, he attends those on Thursdays.
Okay, now, I don't know what Dylan's schedule is, but would you say that it's important for him to attend those if he can?
Yes.
Okay, so if he's missed 3 or 4, those therapy appointments would be a good time for him to kind of bond with Serenity, but also see what she needs moving forward in terms of therapy.
Yes.
Okay, so would it be the department's recommendation that he attend those?
Yes.
I pass the witness.
All right. Okay, anybody else have any other questions they need to ask Ms. Williams?
None right now, Your
All right, then, Ms. Zavala, do you have a recommendation today?
Yes, Your Honor. Serenity is with Dylan's dad and stepmom, doing really great, making great progress. I absolutely think an extension is in the best interest of Serenity, and of course I'm in agreement on that. I do think we just need to keep an eye on Mr. Green's housing situation, make sure that continues to go well. I don't have any indication that it's not, but I do want to keep that on the radar screen in terms of all the household members that might be there. I do think it's really important for Dylan to attend those therapy sessions, so that he can know best what Serenity needs. And think it's in her best interest that both the placement continue and that we keep working with Mr. Green towards what he needs.
Okay, thank you.
Judge, I would have a couple of questions for Mr. Green real quick.
Sure. Mr. Green, if you'll unmute for me.
Mr. Green, I know that some testimony was just given that your current girlfriend is cooperating, or we don't have any issues with her right now. Is that correct?
Yes, sir.
Is she willing to cooperate? So if down the road or shortly, if we needed to ask her to drug screen, would she be willing to do that voluntarily?
Yes, she would. She would be more than willing to. She's already told me several times that she would be more than willing to go do a drug screen or counseling or whatever she needs to do. So,
Okay. All right. I just wanted to make sure that we would be on the same page on that. Thank you.
yes, sir. Thank you.
I have nothing further, Your Honor.
Okay, then, as stated before, I'll find there are extraordinary circumstances and I'll grant the extension in the case. We'll set the new dismissal date of October 11th of 2024. I'll continue the department as temporary managing conservator, and I'll continue the child's current placement. I would find that it would be a danger to return the child home today, but we are most definitely headed in the right direction. So, department will continue to use reasonable efforts to reunify as it is right now, looks like with father. And I make finding that mother is not in compliance with her service plan. Obviously, Mr. Green is. We will have another review hearing on August 6th, 2024. That'll be on a 9 o'clock docket. Ms. Williams, and I do want y'all to start looking at how do we start increasing his time with the child. Mr. Green, I do think it's important for you to go to those appointments, those therapy appointments. So everything that you can make, I think it's really important that you do that. I understand you've got, other things you have to do, but I think to the extent you can make those, it's really important. So I want us to start looking at increasing time and his time to bond with Serenity. I don't know whether placement would be willing to do any additional visits and supervision, but that's something we can always explore.
Yes, ma'am. We can definitely ask them.
Okay. All right, then. I'll see everybody back in August, and Mr. Green, just keep up the good work.
Thank you, Your Honor.
Thank you.
Sorry, yes.
Thank you.
No, it's all right. I can see you nodding your head, yes.
Am I missing something? I thought we did a final on this in November of 22. Is there two sets of kids or parents or
It's a new child.
Yeah,
That
different
was
child.
mom's.
different child? Okay. I have the files combined, I guess. Okay.
Yeah, different child, different case.
I remember the parents that came to the courthouse and signed relinquishments. They were homeless.
We are here set for our final. We are conducting this through Zoom under a finding of good cause and agreement of the parties. We are live streaming, and Ms. Bayless is making our record today. Okay, we'll take announcements.
Daniel Trout for the Texas Department of Family and Protective Services. We're present ready, y'all.
Kenner for the mother, Kimberly Sestata. I'm present and ready. My client is not present and I have had no contact with her.
And I'm Tate Eldridge. I represent the father, Charles Goody, and it's the same. I've not had any contact since they signed the relinquishment for the other child. So I'm here, but he's not.
Stacy Zavala on behalf of Zayden.
Okay, thank you. All right, Mr. Trout, who's our first witness today?
Becky Amos will be our first witness. And how are you familiar with that case?
I received an intake on April 9th, 2023.
And what was that? What did that intake involve?
It was neglectful supervision of Zayden by Kimberly. She tested positive for amphetamines and marijuana at birth. Zayden tested positive for amphetamines. She admitted to last using methamphetamines on April 4th, 2023, because she didn't know, because she was in pain and she didn't know she was pregnant.
Okay. And Zayden was born on April 9th?
Yes.
That's correct. So she admitted to use about 5 days prior to Zayden's birth.
Correct.
Were you able to meet with the parents?
With Kimberly, yes.
Okay. And where did you meet with her at the hospital, or where did you meet with her?
Yes, I met with her at the hospital.
Okay. Did she tell you who possible father was?
She said it could be Mr. Gowdy.
Okay. Were you ever able to meet with Mr. Gowdy?
No.
What efforts did you go through trying to find him?
She told me he hangs out at the Yes Way convenience store and in front of H&R Block on McMaster's, and I drove around several times looking for him.
Okay. Did we look into alternative means instead of removing the child? Did we look for any safety plans or family to place with?
Yes, we looked at her mother to work the Texas Family First program, but she admitted to smoking marijuana several times a month.
Okay. And did you speak to anybody else in the family?
No.
Did you speak to a maternal grandfather?
Oh, yes, I'm sorry, I did.
And was he able to be any type of placement?
No.
And what was the reason for that?
He had a couple of her other kids.
Okay.
And he just couldn't care for another one.
Okay. Had he seen mother in a while?
No.
Okay. How was the child doing in the hospital?
The child was doing good. Wasn't showing any withdrawals or anything.
Okay. Do you know down the road, did the child ever have any withdrawals or?
Yes, at placement, they thought he was having withdrawals, shaking and just showing signs of withdrawals.
Okay. Has mom had prior CPS cases, or have the parents had prior CPS cases?
Yes, I believe she's had 3 other children removed.
Okay. And around shortly before this, she had relinquished on some other children. Is that correct? Or another child?
Yes.
Okay. And that was involved the same alleged father, correct?
Yes.
Where was the child placed?
In a foster home in Amarillo.
After removal, excuse me, let me back up. Do you believe that due to positive screens at the birth of the mother and this child, that it was in the best interest to remove?
Yes,
You believe also due to mom's admittance of meth use prior to the birth, it was in the child's best interest to remove?
yes,
And due to not being able to find any family placement, leave the option of removing.
yes.
After removal, did mom were visits set up for the parents?
I believe so, yes.
Did mom make a visit?
She made one that I was aware of.
Did mom after that, did mom go drug screen?
Not during the investigation.
Okay. Was she taken on April 14th after her visit?
Yes, she was.
But during your investigation, those results were still pending?
Right.
And again, due to the circumstances you believe, or the department believed it was in the best interest of the child to remove at that time?
Yes.
I'll pass the witness, Your Honor.
Okay, Ms. Naranjo?
Miss Amos, were you able to have consistent communication with Miss Sistiata?
No.
And when was the last time you had contact with her?
I believe on April 12th. When I provided her the removal paperwork.
And did she have a stable residence at the time of the removal?
She was living with her mother, I think off and on.
Okay, I'll pass the witness.
All right, Mr. Eldridge?
Just a couple of questions. Have you ever had any contact at all with Charles Goody?
No.
Never been able to find him. Are you even sure he's the dad, really?
No, because she was legally married to Christopher.
Right, Elizarez. And I probably butchered that name, but different last name, not Mr. Goody's last name, right?
Right.
And that's what was placed on the birth certificate, but he's not participated in any services or anything.
No.
Okay, nothing further, Your Honor.
All right, and Ms. Zavala?
No questions, Your Honor.
Okay, Mr. Stroud, anything further for Ms. Amos?
Nothing further at this time, Your Honor.
All right, counsel, is she free to leave at this time?
No objections.
No objection.
No
All right.
objection.
Okay, thank you, Ms. Amos. You're free to go.
Okay, thank you.
Thank you, Ms. Ames.
Thanks.
All right, next witness.
Ms. Shay Karen, Your Honor. And how are you familiar with that case?
I am the worker on the case.
What is your first steps in once you receive a case?
We meet with the parents and go over a plan to mitigate the reasons for removal.
And your testimony reason for removal was positive drug screens at the birth?
Yes, sir.
Did mom ever drug screen for you when you had the case?
No, she
Okay.
did not.
Did you ever try to send her?
I did.
And did she respond to you or just not go, no show? What did she do?
She just didn't go. She was very hard to get a hold of.
Have you ever had much contact with mom?
I have not had contact with her since the status hearing, I believe.
Judge, I would ask to admit exhibit number 1. It's the business record affidavit of drug screens that were pending during the investigation.
No objection.
No objection.
Okay, petitioner's exhibit 1 will be admitted.
Thank you, Your Honor. After you said your last contact with mom was status hearing,
Yes, sir.
what happens at the status hearing? What do we discuss there?
We enforce we go over the family plan and make it an order of the court, and then we set up visitation if there's going to be any.
Can you tell me what family plans of service are?
They're the reasons for removal of the child, and we set up services so that they can hopefully get their children back in their home.
So are they sort of a guideline for
Yeah.
parents work through the case?
Yes.
Were service plans generated for this case?
They were.
Were you able to go over them with mom?
I was.
Did mom sign the plans?
I believe mom signed, but dad did not.
Were you ever able to meet with dad
No, I was not.
with, with Charles Gowdy?
No,
Have you ever been able to meet with him throughout the life of this case?
no, I have not.
What is in these service plans? What type of services are we talking about?
We usually put in parenting, counseling. With this one, it was substance abuse, employment, housing, just to make sure the child would be safe if he was to return home, and drug screens.
Has mom worked any of the services?
No, she has not.
Has she contacted you to try to set up any services?
No,
Has dad tried to contact you to set up any services?
no, he has not.
Judge, I would ask to admit exhibit number 3 and 4, which are family plans of service, exhibit number 3 for Kimberly Sesteta, and exhibit number 4 for Charles Gowdy. These are the certified copies of the plans that were filed with the court.
No objection?
No objections.
No objection.
All right, petitioners exhibits 3 and 4 will be admitted.
Now, Ms. Cairns, you just testified that mom or dad, neither one, reached out to work any service or reached out to set up any services.
They did not.
How often do you try to contact parents or track them down?
I try every month, at least 3 times.
Do you still have the same phone number from the original start of the case, or have you gotten new numbers? How does that work?
The original number wasn't working anymore. And Kimberly's mom told me that she moved out, or rather she kicked her out due to her drug use, and that she was back to being homeless again. So I didn't have any active phone numbers for them.
Have you tried to run searches on them?
I have.
Has anything come back on those searches?
No, there's not.
Do you ever check with shelters or anything like that to see if they're around?
Yes, I do.
Did you in this case?
Yes, I did.
And were they ever found at any of those shelters?
People said they saw them around, but they couldn't tell me where they were.
Okay.
They moved quite often, so.
Okay. Have you ever, just by happenstance, run into them on the street?
No.
At the beginning of the case, did mom sign an admittance of use form?
Yes.
Can you look at exhibit number 2?
Number 2?
Yes, ma'am.
Yes.
What is that exhibit?
That she had smoked marijuana on April 12th.
Okay, and so this is a accurate copy of the admittance of use form that mom signed?
Yes, sir.
Judge, I'd ask to admit exhibit number 2. It's a certified copy of the letter of admittance of drug use by Kimberly Sesteta that was filed with the court.
Any
No.
objection?
No objection.
No
No
objection.
All right, petitioners exhibit 2 will be admitted.
Thank you, Anna. Now, when this case started, we had 2 dads in the case. Is that correct?
Yes.
And one, Mr. Christopher Sesteta, who mom is still legally married to,
Yes,
completed a paternity test,
he did.
found not to be the father, correct?
Yes, sir.
So we have dismissed him from the current case.
Yes.
Did we run paternity registry searches for this child?
Yes.
Could you look at exhibit number 5 for me?
Yes, sir.
And could you tell me what that is?
It's the certificate of registry search for paternity.
And does it state that anybody has filed an intent to claim paternity of Zayden?
No.
Your Honor, I would ask to admit exhibit number 5. It's the certificate of paternity registry search that Ms. Cairns just testified to. It's a certified copy that was filed with the court.
Any objection?
No objection.
No objection.
No objection.
All right, petitioners exhibit 5, which is paternity registry search, will be admitted.
Thank you, Your Honor. Ms. Cairns, how is the child doing?
He's doing very well.
Where is he placed?
He's placed with his biological brother, Broly.
Okay. And how long has he been in that placement?
He has been in there. I apologize.
You're good.
He's been there for most of the time.
Okay. Are they bonding?
Oh, yes, they're very bonded.
Is placement willing to be long-term?
They are.
Have they adopted the brother?
Yes, they have.
Okay. And they plan on adopting Zayden
Yes, they do.
if that becomes available?
Yes, sir.
Do you believe, and is the department asking for termination of the parental rights of the mother, Kimberly Sestiato, as to Zayden Alvarez?
We are.
And is that based on mother's failed work services
Yes.
and based on child being born positive for drugs?
Yes, sir.
Has mother had any visitations since the very beginning?
No, she has not.
Has she reached out to have visitations?
No.
Do you believe that mother could provide a safe environment and home life for the child?
Not at this time.
Has the department offered mother the resources in order to be reunited with the child?
Yes, we have.
Do you believe that it's in the best interest of the child to terminate mother's rights based upon constructive abandonment?
Yes.
As to dad, do you believe it's in the best interest of the child to terminate Charles Gowdy's possible parental rights based upon constructive abandonment,
Yes, sir.
failure to work services,
Yes.
failed to register with paternity registry?
Yes.
Do you believe that dad, has he ever reached out for visitations?
He has not.
Has never reached out to try to work services?
No.
Do you believe he could provide a stable home life for the child?
No, sir.
Has the department offered resources for him to be reunited with the child?
Yes.
And has dad availed himself of those?
No, he has not.
Do you believe it's in the best interest of the child to terminate both parents' rights based upon what we just discussed?
Yes, sir.
And the child is in a long-term placement?
Yes, he is.
I'll pass the witness, Your Honor.
Okay, I was just looking back. I was trying to find, was Mr. Goody personally served or was he published on?
He is an alleged father, Your Honor.
Wow.
So he was not personally served or published on.
Just that we've just done paternity registry.
Yes, ma'am.
We appointed Mr. Eldridge based on that.
On that in prior cases, I believe, Your Honor.
Right. Okay. Yeah, I was just looking because I didn't see citation issued. So okay.
Yes, ma'am. I believe under, was it 16102 C1 that if they're alleged. Yes, ma'am.
Yeah, we're good. Okay. Ms. Naranjo, you got any questions?
Just briefly, Your Honor. Ma'am, when was the last time you had contact with Ms. Sesteta?
In April of last year.
And since then, what was the last effort you made to try to locate her?
I tried contacting her on Facebook just 2 weeks ago. She had tried to reach out to the foster parents.
And were you able to get in contact with her?
I was not. She read it, but that was it.
I'll pass the witness.
All right. And Mr. Eldridge?
I don't have any questions, Your Honor.
All right. And Ms. Zavala?
Ms. Carnes, you've been the caseworker during this entire stage after the investigation, correct?
Yes, ma'am.
And you were able to meet with Kimberly at the beginning. Did you provide her all of your contact info?
I did.
And your contact info hasn't changed over this time, has it?
No, it has not.
Were you involved with the case immediately preceding this one regarding the older brother?
I was not.
As far as you know, does Ms. Sesteta have the address of the St. Francis office?
Yes, she does.
Has she been there before, if you know?
Not that I know of.
And she was involved with a case previous to this one.
Yes.
Okay. She was originally living with her mom,
Yes, ma'am.
and you've been over there at mom's house.
Yes.
And Kimberly's mom has all of your contact information.
Yes, she does.
So if Kimberly had lost your info, she had some easy ways to get them.
Yes, she did.
I pass the witness.
All right, Mr. Trout, any further questions of this witness?
Nothing further of this witness, Your Honor.
Okay, anybody have any further questions for Ms. Cairns?
No, Your Honor.
No, Your Honor.
All right, Mr. Trout, any further witnesses, or does the department rest?
No further witnesses. We'd rest, Your Honor.
All right, Ms. Naranjo, anything to present today?
No, Your Honor, I'd rest as well.
Okay, and Mr. Eldridge?
I have nothing to present. We rest, or I rest.
All right, Ms. Zavala, anything to present?
No witnesses, Your Honor. I would rest.
All right, Ms. Zavala, do you have a recommendation to make?
I do, Your Honor. I do believe it's in Zayden's best interest for the parental rights to both mom and alleged father to be terminated at this time. He is thriving in his placement, has the best smile and laugh. He's placed with his biological brother and has regular access to the older siblings through mom. For that placement to continue and the rights to be terminated is in his best interest.
All right, thank you. All right, at this time, then I do find by clear and convincing evidence that it is in the best interest of the child, Zayden, to terminate the parental rights between the child and his mother, Kimberly Sustacia, based on Texas Family Code Section 161.001, subsection B1, the D, E, N, O, and R grounds, and the best interest of the child under 161.001 B2. I will adjudicate Charles Goody as the father and establish the parent-child relationship between the two of them. I find by clear and convincing evidence it is in the best interest of the child to terminate the parental rights between the child and his father, Charles Goody, based on Texas Family Code 161.001, subsection B1, the N and the O grounds, and the best interest under 161.001 B2. And additionally, his failure to register with the paternity registry under Texas Family Code 161.002 B3. All right, at this time, I'll name the department as permanent managing conservator of the child, and I will dismiss all court-appointed attorneys from the case. After the de novo and appellate timeframes expire, counsel, as always, be mindful that your de novo time does begin to run since I've rendered it in open court. And please do not file a notice of appeal if you're instructed to do so until a final order has been signed and adopted by the referring court. Ms. Zavala will obviously remain in the case as the child's attorney and guardian ad litem. I would also like to include that placement of the child will continue and would not be changed unless there would be some agreement or further court order to that effect. All right, I appreciate everybody. Thank you all very much. And for those of you that are done, then you all have a nice rest of your day.
Thank you. Take care.
Thank you.
Judge. Thank you, Judge.
Judge.
Thank you.
Can you hear us now, Judge?
Yes, I can.
Sorry
Okay,
about that.
that's okay. Your all's case was originally set at 1:30 today. We just got an email from the prosecutor that they've been delayed in another proceeding. So we're going to hear your case at 2:30 today.
Ma'am, just so that the court is aware, I do work at night. I drive a truck and I need to sleep at some point.
And I'm sorry, you what?
I'm sorry, ma'am. What I stated was to please the court and let it be known that I work at night and I need to sleep. 2:30 is like 4 o'clock in the morning to me.
Well, I'm sorry. The prosecutors just emailed and said that he's in another court and in front of another judge, and they won't be ready until later, an hour later. So I'm sorry, but it's going to be set at 2:30. It shouldn't take very long.
Okay. Whatever you say, Judge.
You can use this same link and come back in close to 2:30.
Okay. Which attorney are we waiting for, ma'am?
The prosecuting attorney for the
Mr.
department.
Mr. Buckley or?
No, Mr. Alvey is his name. And
Mr. Alvey.
He represents the Department of Family and Protective Services.
Yes, ma'am. Okay, I understand.
Okay.
I don't understand why my camera isn't working. We had it set up for it to work.
Well, maybe when you log back in at 2:30, it'll send you through some prompts, and maybe y'all can see about it then.
Okay.
Okay, I appreciate it. Thank you very much.
Thank you, ma'am.
Here today, set for our final. We are conducting this through Zoom. We are live streaming, and Ms. Bayless is making our record. All right, we'll go ahead and take announcements.
Daniel Trout for the Texas Department of Family and Protective Services. We're present, ready, Your Honor.
Savannah Kincaid, I represent Miss Barr. I was in contact with her yesterday, but we've tried to contact her this morning. I'm not sure if she's going to be here today, Judge.
William Taylor representing Jawan Zacchaeus Thomas, the father of the child. He is not here. He is incarcerated in Baton Unit, TDCJ. And after I did have an order to appear, but after confirming with Mr. Trout that the relinquishment affidavit that Mr. Thomas had signed had been received and e-filed, I released the prison unit from that order to appear. So Mr. Thomas does not choose to be here.
All right, thank you.
Stacy Zavala on behalf of the child.
All right, Mr. Trout, who is your first witness?
Ashley Delgado, Your Honor. And how are you familiar with that case?
I was the investigator on that case.
How did the department become involved in the case with this child?
I received a report on December 31st, 2022 with concerns of an altercation that occurred between Madison Barr and her then boyfriend, Christopher Ellison, and the child was present during that altercation.
Okay. Were you able to meet with the parents to find out what had happened that day?
Yes.
When were you finally able to meet with the mother?
I believe it was on January 2nd.
And what is mother's name?
Her name is Madison Barr.
And you said you were able to meet with her face to face?
Yes.
Did you discuss the reason for the department's involvement?
I did.
And what did Ms. Barr tell you?
She did tell me that there was an incident that occurred between them two, but she minimized the entire situation.
What type of incident did she tell you?
That she had stabbed her boyfriend, Christopher Ellison.
Okay. Did she state about the incident when the intake came in? What had happened between those two incidents?
That was the incident that led to the report being called.
Okay. Did she go back to the house a few days later?
Yes.
And what was her situation at that time?
Go back to Christopher Ellison's house?
Correct.
At that time, I had parked down the street because I had suspicion she was there. And when I attempted to make contact then, she actually left the house. And she initially denied being there, but then she ultimately admitted to being there.
Okay. After the alleged stabbing, did mom go back to the house a few days later?
Yes.
With the child?
Yes.
Was she intoxicated that day?
Yes.
Did officers have to take her and the child back to her place?
Yes.
To separate the two parties?
Yes, they did.
To your knowledge, did anything come of, at the time, the alleged assault? The stabbing?
I mean, Mr. Ellison was injured. He did have to go to the hospital.
Do you know where charges filed?
I believe so, yes.
Your Honor, I'd ask to admit exhibit number 5. It is a certified copy of the indictment regarding the incident that was just testified to.
No objection.
No objection.
No objection.
All right, petitioner's exhibit 5 will be admitted.
Thank you, Your Honor. And for the record, that is an indictment for ag assault with a deadly weapon from that December 29th incident.
Thank you. Oh, I know.
Ms. Delgado, did the department attempt to work with the mom to prevent removal of the child?
Yes, I tried very hard.
And could you go through the steps of what you tried and what happened in that stage?
The first attempt, we did a safety plan with a Patricia, just drew a blank on her last name. I did a safety plan where she would still be able to have contact with her son, and still be able to care for him without having to place him outside the home or remove. That lasted a few days. Her name was Patricia Bustamante.
Okay.
She called me and said, I can't do this anymore. Go ahead and place him with my mom. So we did a parental child safety placement and placed with Amber Grime, which at that point in time did not realize that Amber's boyfriend had an arson charge, and it was an automatic bar for a parental child safety placement. And then we ultimately did a removal after trying to exhaust any possible persons to either supervise mom with her contact or place the child in a separate home. And then mom's contact be supervised outside that home.
Okay. During that time, did you attempt to get Ms. Barr to drug screen for you?
Yes.
Did she ever drug screen for you?
Not that I can recall.
Okay. During the time your investigation, did mom state who dad was of Cassie's?
Yes.
And who was that?
It was Jawan Thomas.
Okay. Did you make contact with Mr. Thomas?
Just on the phone.
Okay. And what was his situation? Were you able to place the child with him? Was he an option?
Oh no. Oh no.
And what was the reasoning on that?
Well, we've had incidents with Mr. Thomas being assaultive to other women, and we've had history with that. And he actually had an active case with CPS and law enforcement for assaults.
Okay. Did he give you any family that you could try to place with?
No.
Did Ms. Barr give you any other family outside of the 2 parties you've already discussed that we could try to place with or do a safety plan with?
Before removal, no.
At that time, due to the 2 placements not working out and mom not drug screening for you and cooperating, did you ask for removal at that time?
I did.
And do you believe that that was in the best interest of the child?
Yes.
Had mom had prior cases with CPS?
Yes, she did.
Was mom cooperative during those cases?
In the family-based safety service case that was offered to her in 2021, she did not work those services, and Cassius got to stay with maternal grandmother at that time, Amber Grime.
Okay. So in the beginning of this investigation and in prior cases, mom had not been cooperative with services or drug screening.
Yeah, that was a concern. That's why we attempted FBSS, but with her not being cooperative, it wasn't going to work out.
Okay. Once removal was granted, did y'all set up visitations for mom?
Yes, of course.
Did she attend her visitations?
The initial one, I believe she did, but anything after that, I wouldn't know too much about that. St. Francis would know about that.
Okay. On February 1st, did mom cancel a visit?
Was that during investigations?
Yes, ma'am, in your investigative report.
Oh. Yes, that's correct. She did cancel a visit with Cassius.
Okay. You mentioned prior case. Did mom have prior criminal history?
Yes.
And do you know what, was mom on probation or anything at that time? During your investigation?
I'm reviewing my report. I don't think she was.
Do you know what kind of cases she had pending, criminal cases?
Yes, she had a endangerment to a child. I remember she had left her child alone in the car. She had a DWI, a couple of them actually.
Okay.
And we were involved for all of it.
Thank you, ma'am. Your Honor, I would ask to admit exhibits 1, 2, 3, and 4. At this time, exhibit 1 is a indictment and the judgment for deferred adjudication for abandoning and endangering a child. Those are the certified copies of those. Thank you, Your Honor. Exhibit number 2 is motion to proceed with adjudication of guilt on that abandoning and endangering charge. There are, under exhibit number 2, there are 4, the initial and then up to the 4th amended motion to proceed. And then exhibit number 3 is the indictment and judgment for deferred adjudication on driving while intoxicated with a child under 15 years old, involving Cassius in that incident also. And Judge, I misspoke on that. The judgment is not for deferred, it is for straight probation on that one.
Okay. All right.
And then exhibit number 4 is the motion to revoke community supervision for that DWI case involving a child under 15. It also is the original motion to revoke and the subsequent up to the 4th amended motion to revoke. Those are all certified copies.
No objection.
No objection.
No objection on it.
All right, exhibit 4 will be
Ms.
admitted.
Delgado, did at that point after the removal, and you mentioned that child was originally placed where after the removal?
It was with Amber Grime, I believe, which is paternal grandmother.
Okay.
Let me triple check. No, I apologize. He was he was initially placed with Amber Grime, which was grandmother, but then because of the arson charge, we had to place him in a foster home.
Okay. So do you know when that was? Was that on February 1st he was moved?
Yeah, he was moved February 1st from Amber Grime to the foster home.
And when your involvement ended in the case, was child doing well?
He struggled a little bit, but ultimately he was doing okay. He got better as each day went by.
What was he struggling with at that time? Do you know?
He wanted his grandmother.
Okay. But due to people in the house, he was not able to stay there.
That's right.
Okay. And you believe, due to the facts that you just testified to, you believe it was in the best interest of that child to remove at that time?
Yes.
I'll pass the witness, Your Honor.
Okay. Ms. Kingpin?
No questions, Your Honor.
Mr. Taylor?
No question, John.
All right, Ms. Zavala?
No questions, Your Honor.
All right, anything further of this witness?
Nothing further from Ms. Delgado, Your Honor.
All right, counsel, any objection to Ms. Delgado being released?
No objection.
No, Your
No,
Honor.
no objection on it.
All right, Ms. Delgado, thank you very much. You're free to go.
Thank you.
Thank you, Ms. Delgado.
Okay, who's your next witness?
Christy Ashley, and how are you familiar with that case?
I'm the permanency specialist for that case.
And in your case, have you had contact with mom, Madison Barr?
Yes.
And have you had any contact with dad, Juwan Thomas?
Yes.
We'll start with Mr. Thomas real quick. Where is he currently located?
At the Baton unit in Pampa, Texas.
And did you receive the exhibits that I sent out?
Yes, sir.
Okay. Did you, could you look at exhibit number 18 for me?
Okay.
And could you tell me what exhibit number 18 is, what you're looking at?
The voluntary relinquishment of parental rights for Jawan.
Okay. Did, have you been able to review that?
Yes, sir.
Okay. Did, Dad, Mr. Jawan Thomas, did he, execute an affidavit of voluntary relinquishment?
Yes, sir.
And were there two witnesses?
Yes, sir.
Was it notarized?
Yes, sir.
Did Dad sign it?
Yes, sir.
Has the department consented to being the designated managing conservator of the child?
Yes.
And is that by your signature?
Yes.
Was this filed with the court on April 10th of 2024?
Yes.
Judge, I would ask to admit exhibit number 18, which is the affidavit of voluntary relinquishment that we just testified to.
No objection, Your Honor.
No objection.
All right, petitioner's exhibit 18 will be admitted. I did notice that the affidavit didn't appear that he had initialed each page. But I think there's some case law that that's not a fatal flaw.
Yes, ma'am.
So, all right.
Ms. Ashley, as to Dad, are you asking the court today to terminate the parental rights based solely upon his affidavit of voluntary relinquishment?
Yes.
And do you believe that that is in the best interest of the child?
Yes.
Thank you, ma'am. Now, what does the department do when they, or St. Francis do when you first receive a case? What are your first steps?
First steps would be to review case history, reach out to parents, legal parties. I notify the ad litem attorney that I'm going to be on the case.
Okay. Do you work on, what steps do you go through to help with reunification?
Reach out to the parent, we do assessments with them to assist us with building a family plan of service.
Okay.
And then we assign a parent support worker to help them get their services started.
And tell me what family plans of service are.
The family plan of service is a list of services that we would like for a parent to complete in order to help them make positive changes in their life to be able to reunify with the child.
And what type of services do you put in a plan?
Typical plans would include parenting classes, a drug assessment, the OSAR, a psychosocial assessment, individual counseling. Madison's had extra services.
Okay. Are these service plans usually filed with the court?
Yes, sir.
And are they made orders of the court?
Yes.
Now you weren't the original worker on this case, is that correct?
Correct.
But you reviewed the case
Yes.
and you have access to the file.
Yes.
Was service plans done in this case?
Yes.
Did mom sign service plans?
Yes. And when I took over the case, I went back over the service plan with her and had her sign one for myself.
Okay. Your Honor, I would ask to admit exhibit number 12. It is a certified copy of the status hearing order out of Randall County, which is where this case originated. It also involves exhibit number A, which is a copy of the family plans of service that were ordered at that hearing.
Okay, 8 and 12?
Just number 12.
Just 12 right now? Okay. All right, any objection?
No objection.
No objection.
No objection.
Petitioners 12 will be admitted.
Ms. Ashley, throughout this case, you mentioned that you went back over service plans with mom. Has mom worked services in this case?
No.
Has she begun any services?
She told me that she had completed some parenting classes online and that she had certificates for those, but she never produced certificates for those. And we require parenting class programs, that it's like a series of 10 classes, not just individual cherry-picked parenting classes.
Has she started any other services outside of that she told you about?
She completed the WAVE assessment.
Okay.
She was denied WAVE classes and referred to domestic violence support groups, but never attended those.
Okay. So kind of started, but didn't follow up on what came after.
That was the only thing that she did, was that WAVE intake.
Okay. Has mom kept in communication with you?
Not consistently.
When was the last time you talked to mom or met face to face with her?
I have not met face to face with mom since, I would have to go back and confirm, January, is what I believe.
Okay.
The last time that we spoke over text message was March 27th. When she tried to reschedule another face-to-face, canceled a face-to-face. The last actual face-to-face I have with her, I'm confirming that date right now. She did not meet with me in February. She did not meet with me in March.
What, under mom service plans, what other services was she asked to do or ordered to do?
She was asked to complete the WAVE program for the Women Against Violence. For the reason for removal, I'm pulling her family plan up.
And on that, you said she went to the assessment but didn't follow up.
She did the assessment but did not follow up on the next actions. She needed to complete OSAR. She did not do that. She needed to submit to random drug screens. She regularly presumed positive for that because she does not show up for those.
Okay. Hold on 1 second.
Oh, sorry.
On drug screens, how often did you send mom to drug screen?
I attempted to send mom every 2 weeks.
Okay. Do you know approximately how many times she no-showed and were presented positive?
I have on my the court report has the dates listed. I can pull that up. I mean, I only had the case since September. I know that there were no call, no shows prior to me taking over the case. I'm counting, let's see. 1, 2, 3, 4, 5, 10. I would say approximately 15 times. There were no shows.
Did mom ever go drug screen for you?
Yes.
And when she would drug screen, were they ever concerning?
Yes. The most recent drug screens that she did show up for me, one was positive for cocaine and the next one was positive for marijuana.
Your Honor, I would ask to admit exhibit number 17, which is the affidavit of business records involving the drug screen results for Ms. Barr. They were filed timely and served to parties.
No objection.
No objection.
No objection.
All right, exhibit 17 will be admitted.
Did you ever see or are you aware of a drug screen that was performed on the child at the beginning of the case?
I do remember seeing a drug screen for him at the beginning of the case.
Judge, I'd also ask to admit exhibit number 16, which is a copy of the certified copy of the affidavit of business records that were filed February 9th of 24 and served to all parties. And that is the affidavit on the drug screens for the child case.
And I missed your number. I'm sorry.
16.
Okay. I'm just gonna try to pull it up. All right. Any objection?
No objection.
No objection.
No objection.
All right. Petitioner's exhibit 16 will be admitted.
Thank you, Your Honor. Ms. Ashley, do you have number 16 in front of you?
Yes, sir.
And just from the plain reading, was the child negative or positive?
Positive.
For what?
Marijuana.
Thank you, ma'am. Outside of drug screens, did mom, you mentioned the OSAR. Were appointments scheduled for mom for the OSAR?
Yes.
Did she make those appointments?
No.
Approximately how many times were OSAR appointments set up for her that she did not go to?
3, possibly 4.
Okay. Was she supposed to do or court ordered to do a psychosocial with Jennings Counseling?
Yes.
Did she complete that?
No.
Was she supposed to do individual therapy through family support services?
Yes.
Did she complete that?
No.
Did she start it?
No.
Was she supposed to do a rational behavior therapy?
Yes.
Did she do that?
No.
Did she start it?
No.
And you already mentioned about the WAVE program. So out of the services that she was asked to do, she started 1, maybe 2, but never completed anything.
Correct.
Has mom been having visitations?
Yes.
Are they still ongoing visitations or have they been canceled?
They've been canceled. The most recent update from the last court report filed, she canceled 2 visits in March. For April, she did go last week.
Okay. Throughout our case, has mom had, to your knowledge, has mom had legal issues?
Yes.
Has she discussed those things with you?
Yes.
She's aware of the revocations
Yes.
that have been filed. Do you know what other, has she mentioned to you what other type of cases she has?
DWIs and assault and child endangerment.
Your Honor, I would ask to admit, I'll go one by one on these. Exhibit number 6, which is a certified copy of the indictment out of Randall County for ag assault with a deadly weapon and a violation of bond protective order.
All right, any objection?
No,
Objection?
No objection.
All right, petitioner's exhibit 6 will be admitted.
Thank you, ma'am. Exhibit number 7, which is a certified copy of an indictment for burglary of a habitation, ag assault with a deadly weapon, and a violation of bond and protective order out of Randall County.
Any objection?
No objection.
No objection.
All right, petitioner's exhibit 7 will be admitted.
Thank you, Honor. Exhibit number 13, which is a certified copy of the complaint information for a violation of bond protective order.
Okay, any objection?
No objection.
No objection.
All right, petitioner's 13 will be admitted.
And exhibit number 14, which is a certified copy of a complaint information and bond out of Randall County for a driving while intoxicated second offense.
Any objection?
No objection.
No objection.
All right, petitioner's exhibit 14 will be admitted.
Thank you, Honor. Miss Ashley, I'm going to ask you real quick to go back and pull up those exhibits. Tell me when the alleged date of offense was on this.
March 27th
Of,
of 2023.
and we were already involved in this case, is that correct?
Yes.
Can you look at exhibit number 7 for me? What was the alleged date of offense there?
March 25th, 2023.
And again, we were involved in the case at this time.
Yes.
Could you look at exhibit number 13?
Okay.
And tell me the date of alleged offense there?
August 16th, 2023.
Okay. Now, is that the day it was filed or the date of the alleged offense?
I'm not sure I know how to read these. Charge that on
Look
or
toward the bottom of that first paragraph.
okay.
Do you see a date there?
March 27th, 2023.
And we were involved in the case at this point.
Yes.
On exhibit number 14, can you tell me the date there of the alleged?
November 23rd of 2022.
Okay. And we were not involved in the case at this time.
No.
Okay. But mom was, according to other documents that have been presented in evidence, mom was on probation at the time. Is that correct?
Yes.
And she was on probation for a driving while intoxicated with the child in the car, correct?
Yes.
Okay. So looking at these documents throughout the life of our case, has mom seemed to have changed her habits?
No.
Does mom seem to continue to allegedly commit crimes
Yes.
and have run-ins with law enforcement?
Yes, sir.
And due to the few drug screens that mom has completed, she's still testing positive when she does test.
Yes, sir.
But for the most part has no showed, no called, and presumed positive on drug screens.
Yes.
Have you checked into whether mom has been arrested lately?
Yes.
Has she been arrested lately?
Yes, sir.
Have you discussed that with her?
Yes.
What was mom arrested for?
DWI.
Can you look at exhibit number 15 for me?
Yes.
Can you tell me what that is?
A jail record search.
And does it have the website at the top and the bottom of the page?
Yes.
And is that a government website?
Yes.
Have you visited that website?
Yes.
Does what you have seen on the website mirror what you were seeing in this exhibit?
Yes.
Judge, I'd ask to admit exhibit number 15, which is should be a self-authenticating printout of a government website showing Ms. Barr being arrested for and booked on a DWI.
All right, any objection?
No objection?
No objection.
No objection.
All right, petitioner's exhibit 15 will be admitted.
And Miss Ashley, can you look at that exhibit for me and tell me when the booking date was?
March 15th, 2024.
So less than a month ago?
Yes.
And now understanding that is just a booking, she is not, have you seen that she's been charged with this yet?
No.
So it's just a booking and arrest.
Correct.
But does that go toward your opinion that she has not changed her habits at this time?
Yes.
Due to, at this time, is the department asking for the termination of the parental rights as to Madison Barr as to the
Yes.
child case? And can you tell me what that is based on? What the reasoning for that is based on?
She has not completed any of her services. And we feel that it's not safe to return Cassius to live with her.
Due to mom's criminal records that have been put into evidence today, is mom, she's being revoked on some felony charges. Your understanding is that possible, looking at possible jail time?
Yes.
Due to her multiple cases she's been charged with during our involvement with the case. Have you formed the opinion that mom has not changed any habits?
Yes.
And do you believe that puts Cassius in a dangerous environment if returned to mom?
Definitely.
Do you believe that it is in the best interest of Cassius to terminate the parental rights of mom?
Yes.
Based upon her legal involvement with criminal, the safe environment, failure to work services?
Yes.
Her failure to drug screen or continuously testing positive?
Yes.
And you do believe that's in the best interest of the child?
Yes.
Where is the child placed right now?
He is in a foster placement with, let's say their names.
Well, they'll say their name, just he's in a
Okay.
placement.
He's in a foster placement that he's been in since I've been in the case.
Are they possible long-term placement?
They are licensed and willing to adopt.
Are they essentially waiting to see the outcome of this case on whether they can proceed with adoption?
Yes, sir.
And again, as to dad asking to only terminate based solely upon the voluntary relinquishment.
Yes.
I'll pass the witness at this time, Your
Honor. Okay. Ms. Kincaid?
Thank you, Your Honor. As to mom and her service plan, does she have stable housing?
I'm unaware at this time.
Okay, so do you know if she has living in a house, an apartment, anything like that?
The last time she met with me in January, she was living in her own house, but she refused to meet with me face to face in February and March. And in one of our conversations, she told me that she was moving out of that house.
Okay, does she have transportation?
Also, I'm unaware. When I met with her in January, she did have a car, but since her DWI, she has mentioned that she's been Ubering. So I don't know if her car is in impound or if something, I'm not aware.
Okay, but if she's taking an Uber, she's able to transport herself freely.
Yes.
And is she working anywhere?
She's working, she reported to me that she's working at Buffalo Wild Wings and Bodegas.
Okay, and do you know how long she'd worked at Buffalo Wild Wings?
Since January.
Okay. And she reported to you that she did some of the parenting classes, they just weren't approved parenting classes?
And she never gave me certificates of completion.
Okay. And regarding the criminal charges that she's got pending, so far, none of those have resulted in convictions. Is that correct?
Correct.
Other than there's a DWI that she was on probation for. Is that correct?
Right. Yes, she is on probation for one.
All right. I did need to clarify that, but all the rest of these are pending. They're not final convictions.
Correct.
Okay. Thank you. I'll pass witness.
Mr. Taylor, any questions?
No question, John.
All right, Ms. Zavala?
Ms. Ashley, I just want to clarify something about the placement for Cassius. Is it correct that this is actually a fictive kin placement for Cassius?
It is.
Okay. And he has now been there over a full year, is that right?
Yes.
And would you say he's thriving there?
Yes.
And they're on top of any medical needs that he has?
Yes.
I pass witness.
All right, Mr. Trout, any further questions of this witness?
One quick kind of clarification. As far as criminal cases, she is on probation for the DWI with a child under 15, correct?
Yes.
And they filed motion revokes on those.
Yes.
She's also on deferred for an abandoning and endangering, correct?
Yes.
And they filed motion revokes on that also.
Yes.
Okay. Nothing further, Your Honor. I'll pass.
Okay, and anybody else have any follow-up questions for Ms. Ashley?
No, John.
No, Your Honor.
No, Your Honor.
All right, does the department rest?
Department arrest, Your Honor. No more witnesses.
All right, Ms. Kincaid, anything to present today?
No witnesses, Your Honor. I rest.
Okay, and Mr. Taylor?
Since the relinquishment has been admitted, Your Honor, I have nothing further, no witnesses, nothing further. Rest.
All right, Ms. Zavala, anything to present?
No witnesses, I rest.
All right, and do you have a recommendation to make?
Yes, Your Honor. I do believe it's in Cassius's best interest that parental rights be terminated at this time based on the evidence presented. He is currently in an adoptive home with a family who had a previous relationship with him, and is thriving there. And I recommend that that placement continue until adoption can be finalized.
All right, thank you. All right, everybody close?
Rest and close, Your Honor.
Yes.
Close.
Yes, sure.
All right, at this time, then I do find by clear and convincing evidence that it is in the best interest of the child to terminate the parental rights between the child and his father, Juwan Zacchaeus Thomas, based on his voluntary affidavit of relinquishment of parental rights under Texas Family Code section 161.001, subsection B1, the K grounds, and the best interest 161.001, subsection B2. I find by clear and convincing evidence it's in the best interest of to terminate the parental rights between the child and his mother, Madison Ann Barr, based on Texas Family Code 161.001, subsection B1, the E, L, N, and O grounds, and the best interest under 161.001, B2. At this time, I will name the Department of Family and Protective Services as the permanent managing conservator of the child, and I'll dismiss all court-appointed attorneys from the case after the de novo and appellate timeframes have expired, with the exception of Ms. Zavala, that will remain as the child's attorney and guardian ad litem. Counsel, as always, be mindful that your de novo timeframe does begin to run since I've rendered in open court. And if you are instructed to file an appeal, please wait to do so until a final order has been signed and adopted by the referring court. All right, I appreciate everybody. Thank you all so much. Mr. Taylor, I'm glad you are back at work and seem to be feeling better. And
Thank you.
everybody have a nice rest of your day. I will be back at what was going to be a 1 o'clock docket has now been pushed. We are conducting this through Zoom under a finding of good cause and agreement of the parties. And we are live streaming. I am recording this to the Zoom cloud. I don't have a court reporter this afternoon. Okay, we'll go ahead and take announcements.
Todd Abbey on behalf of the Texas Department of Family and Protective Services. President, ready to proceed, Your Honor. In lieu of any testimony, I think we'll have an announcement we can make.
Brooks Barfield, attorney for Cheyenne Sosa. Ms. Sosa is present. We do have an agreement, Your Honor. My client, who is calling in from Senecor, she's presently in their program. She has agreed to the order of services, and try to mitigate the circumstances. So with that said, we're in agreement with the court entering an order today.
All right.
Sorry.
Oh, go ahead.
Stacy Zavala on behalf of the children.
Okay. All right. So, Mr. Abbey, just so we're clear, if you want to let's go over exactly what services that the department is requesting, Ms. Sosa, so make sure she understands everything.
Yes, Your Honor. First of all, we would ask that she complete the Senate program. Second of all, that she submit to a family-based safety services assessment and complete the services as determined in that assessment, including counseling, parenting, any further drug and alcohol evaluation recommendations from our Senate a psychological evaluation, and then allow the access to the children and to her home when she's out. And then we would also ask that if the children need some counseling, that they be allowed counseling. And I think there are some speech therapy classes being put in place for at least one of the children.
All right. And that, obviously, the counseling would be age appropriate. I mean, we've got a 1-year-old, a 3-year-old, and then an 8-year-old. But
correct, John.
Okay. Okay, let me just ask a couple questions, and this is kind of based on the affidavit. But Ms. Sosa, I know you're currently in Senate, and I commend you for making that move and taking that step. When you finish that program, will you be going back to live where you were?
I am not too sure.
Okay.
Hopefully I can get into something else from here.
Okay. All right. So I just didn't know if the children would continue to be with, I know the first name is Alex, Mr. Flores, with Mr. Flores, or if they were going to be with you, or what, if you knew right now, if you had a plan about that.
If I do go back to living where I was at, they would still be with Alex Flores. They would still be in his care because I need to get a job and get a job in place and outpatient services in place for here and really focus on that stuff.
Okay, but you would have access to the kids and be there for them and help with their care and all that, correct?
Yes. Yes.
Yeah. Okay. All right. All right. So you understand kind of what they're asking you to do.
Yes, but I do have a question if I have to stay inpatient for 30 days or if they were fine with me going to what is it called? Intensive outpatient program instead, so that way I can do their intensive outpatient program but also look for a job and start working.
Okay. Has anyone at Senecor suggested that you might be able to do that?
Yes.
Okay. All right.
Yes, we would not have an objection to that.
Okay. All right. So that's fine if you want to choose to do that. Just know that, there's more coming and going and getting there and all that kind of thing. So, so it's a lot on an intensive outpatient, basis, but that's fine. I understand why you need to be looking for work too. So.
Yes, ma'am.
Okay. All right. Okay, then, Ms. Zavala, are you good with all this?
Yes, Your Honor, I do believe that's in the best interest of the children.
Okay, Ms. Zavala, have you had access to the children yet?
I have not yet.
Okay, so since they are, I guess, kind of still in the care of Mr. Flores, correct?
And I believe it's Donna, is that correct? I may not have the most up-to-date information. Or I might have the wrong name, actually.
It would be my mom, Kelly O'Neill, and Alex.
Kelly. Sorry, that's what I meant to say. I don't know where Donna came from.
Okay, so I guess that my question is, I just want to be sure they're aware, that Ms. Zavala needs access to the children and that they will allow her to have access to the children when she needs that.
Yes.
Okay. All right, then, based on the agreement and also on the evidence that had been presented to me, I think that the court ordered services, is in the best interest of the family and of the children. And so I will go ahead and order those services as Mr. Albee has outlined. And I wish you the very best of luck in either the inpatient or the intensive outpatient. We will get back together on July 2nd for another, we call it a compliance hearing. It's kind of a check-in to see how everything's going and, to see what progress we're making, or if there's something else we need to discuss, or, something that we think would be beneficial to you and to the kids. So that'll be on a 9:00 docket, and Mr. Barfield can kind of explain that to you, but I'll start my docket at 9. That doesn't mean your case will be right at 9. It could be anywhere, in the morning. But they'll let you know what time your case will be. Okay. We're not always right on time. We try hard, but we do our best. So anyway, they can let you know. So be sure you stay in contact with Mr. Barfield's office. If you have to change a phone number or anything, just be sure you let all these folks know that.
Yes, ma'am.
Okay. All right. I wish you the very best of luck, and I'll see you back in July.
Thank you.
Okay. All right. Thank you. You're free to go. Request for a order in aid of investigation. We are conducting this through Zoom. We are, this is a Childers County case. And we are recording this to the Zoom cloud. I don't have a court reporter this afternoon, so if anybody needs a copy, just let us know and we'll make it available. All right. Mr. Albee, how many witnesses you have today?
Just one, Your Honor.
Okay. All right, then. Is that Ms. Hooks?
It is.
All right, Ms. Hooks, if you will, please raise your right. Mr. Albee, you may proceed.
Thank you, Your Honor. Ms. Hooks, you're a investigator working with the Texas Department of Family and Protective Services?
Yes, sir.
And in that capacity, you've been assigned to do an investigation into the home of Joanne Holt and Jason Holt.
Yes, sir.
And what were the allegations that caused you to begin your investigation?
Well, I received a report that Mr. Jason Holt was extremely intoxicated and made threats to 17-year-olds that he threw her to the ground and grabbed her neck, and that Mrs. Joanne Holt was not protective.
And what did you do to begin your investigation?
I ended up calling the reporter and made contact with children. I made contact with the reporter and the children at school.
And did you talk to Kendall at school?
Yes, sir, very briefly.
And did she confirm that the incidents occurred, which started the investigation?
Yes, sir.
Did you talk to Peyton at school?
Yes, sir.
Did she confirm that the incidents that started the investigation happened?
Yes, sir.
Did you then attempt to talk to Mr. and Miss Holt at their home?
Yes, sir.
Did they allow you to come into their home?
No, sir. Joanne did not want to speak to me and exercised her right to refuse to speak to me. Mr. Holt did meet me outside where I reviewed the 3010 with him.
And after you reviewed the 3010 with him, did he also conclude your interview and not discuss the matters that need to be discussed?
I'm sorry?
Okay. What did Mr. Holt do after you read him the 3010?
He refused to speak with me.
Okay. Was law enforcement also working an investigation in this case?
Yes, sir.
And did they schedule a forensic interview for both of the children?
We scheduled one for Kendall. It was sorry. We scheduled one for April 9th at 10 a.m.
And did Mr. and Miss Holt refuse to allow Kendall to be forensically interviewed at that time?
No, Mr. Holt informed me that he didn't know the status of Kendall and couldn't promise if she would be there or not.
Did she appear at the interview?
No, sir.
Today, so that you can complete your investigation, are you asking the court to order that you be allowed into Mr. and Mrs. Holt's home to investigate the safety of that home?
Yes, sir.
And then to allow you to schedule a forensic interview for Kendall and or Peyton to discuss the events that took place that caused this investigation to start?
Yes, sir.
If the Holts don't want to take Kendall to the forensic interview, are you asking the court to order that you be allowed to transport Kendall to that?
Yes, sir. Yes, sir.
I'll pass witness, Your Honor.
Okay, Ms. Holt, is there anything you would like to ask Ms. Hooks? And this is question and answer. So I'll give you all, each of you, the opportunity to tell me what you want to tell me, but this is just your opportunity to question her.
Well, my question is, am I allowed to take her since my husband can't have anything to do with her for 30 days? Because she's not here at my house.
Okay, I think it's hard to hear you. You're saying, are you allowed to see her?
No, am I allowed to take her to this bridge interview if it's ordered to be done? Because she's not in my house because she can't have anything to do with her father for 30 days.
Correct. Yes, he would not be permitted to transport her, but you certainly would be.
Okay, and what's the reason for this bridge interview? Because per Ms. Hook's report, there were no red marks on her neck, as stated in the officer's report. She asked if Kendall was okay. Her report says she's healthy, happy, no marks.
I don't have the report in front of me, so if she's testifying about what's in that report, I would object to that.
Okay, but furthermore, hang on, it's not your turn, Mr. Holt. Okay, there are procedures to this proceeding. Okay, so Ms. Holt, you need to, if you have a question you want to ask Ms. Hooks, then ask that question one topic at a time. Don't take it one thing at a time.
Okay, I don't see the need for a bridge interview due to Mrs. Hook's own words.
Okay, that's not a question for Ms. Hooks.
So I don't know, Jason. I've never done this before. Why is the bridge interview necessary?
That's a good question. Okay, Ms. Hooks.
So with the report that we received, from what Kendall is stating, there has been several events with Dad abusing her. So we wanted to schedule a forensic interview, with also law enforcement being involved. We were wanting to screen Kendall for physical abuse.
All right, Ms. Holt, do you have another question? Okay. All right, Mr. Holt, do you have any questions for Ms. Hooks?
Yes, ma'am.
You're because I think because you all are sharing the, you might get the microphone directed sort of towards you.
Is that better? Yes, ma'am, I do.
Yes, much better.
Yeah. My question pertains to the document that was sent to us in reference to this hearing. Number one, there's nothing that was stated, and I'm asking Mrs. Hook, nothing in your report states anything that you've testified today about speaking to my daughter. You've taken a statement from her at the school. In your statement, ma'am, you state nothing about Kendall and what you've told this court, that she advised you anything of any kind of abuse. Why was that not included, ma'am?
Your Honor, I'm going to object because I'm not sure. Wait, Ms. Hooks. I want to object. I'm not sure what he's referencing as paperwork. Because the petition includes an affidavit, and the questions I asked came right off of that affidavit. So
that's what I'm asking. I'm asking in reference to the affidavit, Mr. Albee.
Okay. And then it specifically, well, I will continue to object as reference of the facts, because the affidavit sets forth the conversation that Ms. Hooks had with Kendall and with Peyton.
Yes,
Okay,
it does.
hang
And
on.
that's not what.
Hang on. This is not an argument between you and Mr. Alley, okay?
Yes, ma'am.
Your question to Ms. Hooks was, why didn't she put anything in the affidavit about that? So I'm going to let Ms. Hooks respond whether she did or she didn't. And if we need to direct you to a certain place in the affidavit, we can do that.
Give me 1 second. I have this pulled up. So I did not include where I asked her about the abuse, and my apologies, but I did include.
Well, that's my
the
objection there, Judge, on that behalf. Mr. Alvey's attempting to bring evidence into your court and predicated on what she stated, or what he's stating rather, is in the affidavit, and that was not ever given to us, nor is that ever stated. Okay, well, your objection is overruled because the witnesses testified also about it. This is not only just what's in the affidavit, but based on her sworn testimony today.
Understood. So Mr. Alvey asked her a question. She answered it. She's answered your question why it wasn't in there. Basically, that she failed to put it in there. All right. Do you have another question for her? So it's stating, Mrs. Hooks, that Kendall advised you these things, you just didn't put it in there?
I'm sorry?
Is it your testimony now that my daughter Kendall advised you of these abuses, these alleged abuses, and that you just simply failed to put them in your affidavit?
Yes, sir. I did not put that part in there. I apologize.
Is there a specific reason as to why that was not put in there? It's a pretty big piece of evidence, I would think. Would you agree?
Well, from what my supervisor stated, was supposed to be a brief conversation so we could set up the forensic interview for them to screen her for the abuse.
I see. Mrs. Hooks, did you ever have a chance to speak with any of the officers involved with this case?
Yes, sir.
Okay. And did they advise you that they'd taken a statement from Kendall already in reference to this deal?
Yes, sir.
Okay. Why does your office feel the need to question her twice? It's highly prejudicial in my experience with that.
Objection to the sidebar, Your Honor.
That's a comment. That's not a question. If you want to ask her why the department needed to interview her as well, she can answer that question.
I'm curious as to why the second statement is needed. To be honest, the third, to be honest, if that's
again, Your Honor, I'm going to continue to object.
Just a question, Mr. Holt.
Why does the department need another interview after she's been interviewed twice?
Because Ms. Kendall stated from what the officers have said, that this has not been the first time that something like this has happened.
I do not feel that answers the question. She's been interviewed twice. Why do you need to interview her again?
Objection, Your Honor. That's been asked and answered. Ms. Hooks has answered it to the best she can.
Well, okay, and I'm going to just step in. Mr. Holt, when the department receives an intake of any kind or any allegation of child abuse or neglect, they are legally bound to investigate and, if at all possible, to interview the individuals involved.
I agreed, Your Honor. She is also admitted.
She is simply doing her job, what the law requires her to do, by asking to talk with the child. Now, just for you and your wife's benefit, Ms. Hooks' answer regarding her supervisor instructing her to have a brief conversation with the child, that is because they wanted to have a forensic interview done of the children, which is done by experts in this field. The people at the bridge are experts in their field of forensically interviewing children. So that also goes to answer your question. She had a brief conversation because we wanted the children, or they wanted the children, to be forensically interviewed by a professional. So I don't know if that helps you or not, but I'm just telling you that that's the reason those things happen the way they do.
Well, I understand, Your Honor. I'm just stating to the point of fact that they've been forensically interviewed twice already by professionals in this field. Police officers who have been allegedly trained to handle these kinds of cases, caseworkers that have allegedly been trained to handle these kinds of cases. So twice they've been interviewed, and now they're being asked to be interviewed again.
Okay. So let me try to answer that for you. Yes, they were interviewed by law enforcement. And yes, I would consider law enforcement to be experts in the field of at least interviewing people. All right. They are not experts necessarily at forensically interviewing children, but they certainly have a higher level of expertise than the average individual. Now, that was the Children's Police Department. That is not the Department of Family and Protective Services. And so it's, separate entity, separate agency. And as I've explained to you, the department is required by law to follow up and to interview. So it doesn't matter where law enforcement has done, they are required to do so. Ms. Hooks was instructed only to go very superficially with the child or the children because they wanted the experts to do that. Does that answer those questions for you?
Yes, ma'am, it does. But the thing of it is, here, the other thing, Your Honor, is Kendall's 17. She's not she is a child in the family code.
Okay,
but she's
Ms. Charles,
not young.
Well, hang on. We're going to get to all that. Do you have any other questions for Ms. Hooks first?
Yes, I do.
Okay. Then we'll take your next question.
Yes, sir. Bear with me for a second. Mrs. Hooks, in your statement to Mr. Alvey, or to the court, I rather should say, you stated that you observed Kendall at the school there when you went and talked to her, and she appeared to be, according to you, let's see. Seemed to be very happy and good, high spirits. Sorry, Your Honor, I'm not trying to waste the court's time. It's just going through this affidavit, ma'am. When you observed Kendall, was there anything about her person or her how she was then that would indicate to you and your expertise that a forensic interview would be needed?
Objection as to her expertise, Your Honor. I'm not sure that Ms. Hooks has the expertise to make a decision as to whether or not there is a forensic interview that's needed. She's asked for one, and now we're here before the court asking for one.
Okay, well, that's a good question. I'd like to ask Ms. Hooks. According to the affidavit, did she request the forensic interview, or did law enforcement? Because according to this affidavit, she wrote and stated, Ms. Hooks, is it not true that law enforcement requested you get this forensic interview, not yourself?
What was the question, Mr. Holt? I'm sorry.
Did law enforcement in Childers County ask you for the forensic interview, or are you attempting to get the interview yourself?
Your Honor, I'm going to object as relevant.
You asked the question, Mr. Al.
I'm going to allow her to answer it. She can answer it.
So yes, sir, I stated in my affidavit that I spoke to the law enforcement who instructed me to set up a bridge interview. I did set up that bridge interview myself, sir. Yes, I called and scheduled the bridge interview
Under
for
the instruction of the Childers Police Department, not your own.
According to the objection relevance, Your Honor.
Because that's what the statement says, Your Honor.
Miss, hang on. I need to rule. Okay. I'm going to rule. I'm going to allow her to answer it if she can.
From my sorry.
Go ahead.
From my supervisor's instructions and from the police officer's instructions, yes, sir, I was instructed to call and schedule that bridge interview.
In your affidavit to the court, Ms. Hooks, it appears through the writings of it that you've either observed some kind of report from law enforcement that we have not been given. Where I don't understand where this information is coming to or coming from in reference to me causing bodily injury to Kendall. I think something to the phrase of putting her on the ground, that I put her on the ground. I don't know how that information, how was that information obtained by you, ma'am?
I've been instructed to keep the reporter confidential.
Okay. So why did you fail to use use that into your report, advising that that you were advised by someone confidential, or you use a pseudonym that would be acceptable in a case like this. Why was that not added to the report?
Mr. Holt, it's state law. It is state law in the state of Texas. Reporters to the department, their identity is not disclosed.
Yes, ma'am. I'm fully aware the state law used to use it all the time, and a pseudonym is usually used.
Well, no, sir, not really. But anyway, I'm not here to argue with you either. But if you've got a question for her, ask her a question.
Your Honor, I don't have really any more questions, but I'm not trying to make a headache out of this. It's just I've listened to the cross-examination of Mr. Albin and into Mrs. Hooks, and everything that was asked and answered, very little of it is actually in the affidavit. Mr. Albie stated that he spoke directly from it, and I've proven that there was more than a couple of spots where that was simply not the fact.
Well, again, Mr. Holt, he isn't limited to presenting evidence that's just in the affidavit. He can ask for Ms. Hook's testimony.
Yes,
so
yes, ma'am. But that was his own statement to the court, ma'am, was that his questions came directly from the affidavit that I have present. Basically, Your Honor, what I'm saying is that I don't have apparently the same stuff that they do, and it's very hard for me to cross-examine a witness that it's clear by these proceedings that she clearly and he clearly knows more than we do. I find it prejudicial, to say the least. We don't have the same kind of footing as Mr. Albie and Mrs. Hooks about the information of his case, because I'm telling you, it's clearly not happening. We don't know of any of these allegations. They're new to us too.
Well, you have the same affidavit. I'm assuming that it is the same affidavit. There's only one affidavit that was presented with this.
Right, from Mrs. Hooks.
But I don't know whether they have the whether she also has police reports, whatever else she may have, it's for investigation. But Mr. Holt, you're welcome to ask her any questions based on that affidavit, just as Mr. Albie did. I mean, it's I could go through that affidavit and ask all sorts of questions.
Well, to be honest, Your Honor, I'm a little taken back by the proceedings at all today, because according to the documentation that we received, we were told that we would be able to speak with our attorney before any kind of hearing took place, that we would have 20 days to respond to this, that we would have that time to be able to confer with an attorney, and we've not been given any time at all.
I don't know who gave you that advice, but this is not a legal removal of a child, nor is it an order to participate. And the family code does not authorize the appointment of attorneys in an order in aid of investigation. It's
not
not
what was given, Your Honor, right here.
Well, it's probably standard language in a citation that
yes,
that district clerk generates. Okay, that was just to notify you of today's hearing. But I will tell you that the statutes in Texas do not permit me to appoint an attorney to you for this kind of hearing.
No, ma'am, I'm not asking.
What we're here to do today is to decide whether or not the department can have the children forensically interviewed, to see if there's any further action needed, and to see the home to make sure that the conditions of the home are safe for the children. I mean, I
understand that. I want it on file now. I mean, I don't have any other questions for Mrs. Hooks at that point. I just wanted to understand. We got the citation, okay? Inside the citation is the affidavit from Mrs. Hooks. That's not contained in anything else that we received. When I got this yesterday, ma'am, from the deputy, we were served yesterday, notifying me of today. And when we looked at the notice of hearing, it was attached with the citation. And through all of that documentation, it basically advised us that we would have 20 days to employ an attorney before we had this kind of hearing.
Well, I apologize that the clerk's office generated what is typically a citation that is used in family law cases. That this is kind of an order in aid of investigation is sort of a very unique process. I'm required by law to hold a hearing, and in fact, Mr. Holt, I don't even have to have this hearing. I could just sign the order without engaging you or Mrs. Holt, but I chose to allow you all to appear to give me your side of this,
right,
which I'm going to give you the opportunity to do. But again, it's not a legal removal of the child. It's not, if I grant this order, there's no further court action in this procedure, as long as you abide by whatever order I render today. Now, I'm going to give you all an opportunity to tell me your side of this, so that, which is why I've set it for this hearing. And the law requires me to do that very quickly.
Thank you for setting me straight on my confusion of the matter.
Yeah.
Thank
and
you.
I understand why you would be confused about it. And I think the department probably needs to have some discussion. If they're going to use citations to give notice to parents, we're going to have to do something about that, because that's very misleading. So, and in fact, I'm not sure citation is even required.
That's what we received. I'm just letting Your Honor know.
I understand, and I fully understand why it would be confusing to you. So, okay, Ms. Holt, is there anything that you want to tell me about? Not a question for Ms. Hooks, but anything you want me to know?
I'm not a neglectful mother, especially if that in the affidavit was actually true. I wouldn't be married to this man and my kids wouldn't be here. Discipline is totally different than abuse. He was disciplining her. She went to move, and so if abuse was going on, I would not be here. Discipline is totally different, and I don't get involved when it's discipline. I don't pick sides during discipline. And that's all I have to say.
Okay. All right, Mr. Holt, anything that you want to tell me about this? And Mr. Holt, I will admonish you. You've got to, as you well know, I mean, I think some charges were filed against you.
Yes, ma'am.
So just do be aware of your privilege against self-incrimination.
Yeah, yes, ma'am. All I know is this is all new to me. Reading Mrs. Hook's report, we were shocked and taken back in reference to what some of it is. It's new to us. Okay, Your Honor, just to let you know, I'm a 20-year retired police officer veteran. I'm also a certified expert in domestic violence through SafeVic, child abuse. I have argued many cases as a police officer against Mr. Alvey for many years. Okay, he was the defense attorney on probably, if I had to guess, well into the hundreds of and possibly thousands of cases when I was a police officer. I know Mr. Alvey well, which I don't know if he remembers me. All of that, like I said, I have a 17-year-old daughter who tends to be, what's the phrase best? A little dramatic at times, especially with friends and things, and tends to buck the system with mom and dad. Now, she was never injured. Okay. There is no signs of any kind of injuries. I have never done anything to her to hurt her. Case in point, there's, as Mrs. Hook stated in her affidavit, there's no history of CPS being involved with our family before. And I have as you could possibly imagine, I have a pretty high-profile family for small towns. There's a lot of people that know us and have for many, many years. People see us coming and going. I've never had these kind of none of this stuff. My daughter simply tried to walk away from me and I turned her around. That's it. Okay. There was no picking her up and slamming her down. I do not have the capability as a father to do that. However, I do discipline my children, as according to the Texas state statute says I can. But as Ms. Hook stated in her own affidavit, she observed Kendall the following day after these allegations occurred, said in her affidavit that she looked at my daughter, at Kendall, and at Peyton, and found no signs of any kinds of injuries. I would think, in my time as a police officer, 20 years of working domestic violence, if someone was to be picked up and thrown onto the ground, there would be abrasions, contusions, possible lacerations. None of that is stated here, that Mrs. Hooks observed any of that. Now, I don't mind my daughters being involved with anything that Mrs. Hooks needs to do. And I will tell you this, my 17-year-old daughter, as per the county judge here, and as a part of being arrested, and I know how this goes, you have a little bit of a reprieve from being around dad for a while. So she's not at home, and I have not discussed with her, and I've complied with that order about not having any contact with her. So, of course, I haven't been able to see if she can go do a bridge interview. Although I will tell you this, I have heard that from my wife, that when they were speaking, my wife can speak with her, but my wife told me that she simply did not want to participate. Now, I told Mrs. Hooks while she was here, I would like to remind you, Your Honor, that I said as she was leaving, I don't know if she's going to participate or not. I don't mind that. My 17-year-old daughter, who is basically an adult, who just, in the family code is just shy of being that, decided that she didn't want to participate in that. All I was doing was, okay, whatever. As a dad, whatever. Even said that to Peyton. Now, Your Honor, there's nothing in the report shown here that's been filed to your court where Mrs. Hooks stated anything about finding abuse or any kind of pseudonyms or saying that she was able to obtain evidence that was consistent with abuse or neglect in the home. I don't understand why we would even need any of this. To be honest, I've been involved in many bridge interviews in Amarillo, in Pampa, in many of those areas. I've been the investigating officer sitting next to the CPS caseworker while we investigated crimes that are a heck of a lot more serious than what I'm accused of. Okay. And in that, it has been my experience that if we continue to interview and pick apart and pick at these kids, it can be detrimental to their mental health. And I'm trying to protect my daughter. Now, I'm not, like I said, once again, reminding the court, I'm not trying to say that she can't. I haven't talked to her. She makes her own mind up on it. She doesn't want to go. She said she doesn't want to go. And my understanding is that she was advised that. Mrs. Hooks was advised that we don't wish to go do any of that. We're not trying to hold them back. As far as coming in and doing a house study, Mrs. Hooks is welcome to come back. She can come sit for dinner for all we care. She's welcome in our home. She can come do what she needs to do. Other than that, that's it, Your Honor. I don't know. It's just, I will promise you this. My daughter is not in any danger from me. Peyton's not in any danger. I find it very unique, to say the least, that if CPS actually believed that my children were in as much danger as they think that she is, apparently, that why is Peyton still here? Peyton's not, she's not been removed from the home. Like
well,
Kendall
neither child was removed from the home, Mr. Holt. You because of the protective order, whatever arrangements you all made about Kendall, you all made, but it's not because the department removed the children from the home, because they did not.
No, and I understand that. And let me rephrase. I didn't mean to cite that. What I mean is to cause a separation between us for the allegations that have been made.
Okay. And I have nothing to do with that protective order. A different judge is the one that did that. So
understand, and we're complying with it. We're complying with the law.
I understand.
But we just find this highly prejudicial, to say the least, because there's no evidence here to suggest it's been given to your court or anything that there's any kind of abuse going on.
Well, that Mr. Holt, the evidence is the statements that were made and the outcry that was made by the child, and it's the kind of thing that the law requires to be investigated. So I am going to grant the department the order in aid simply to do what they've requested, which is to just see the home,
sure,
and then to either for their mother to transport the children to the bridge to be interviewed by experts, and or Ms. Hooks will transport one or the other. But the whole purpose is for the expert the experts at the bridge to conduct the interview, because they are well versed in with children that maybe they're exaggerating, maybe they aren't, but that's why we want an expert to interview the child.
I surely understand that, and I agree with being thorough. I don't want to do anything about it. All I'm saying is that I just feel that it's a waste of time predicated on what my wife has told me, that they chose not to participate. And it just seems like, the state through CPS is trying to push the issue, and that's fine. As I stated to you before, I don't have a dog in the hunt for them not to be interviewed forensically. I have no problem with it. I'm just going off what Peyton has told me, what Peyton has told her mom. They chose not to participate, and I don't know what they hope to gain by it. That's all.
It's just simply to either to rule it out as an investigation, and or to, if further action is needed. So if you've said yourself you don't have an objection to the kids being interviewed, so anyway, we're gonna interview them, and the department's just going to take a look at the house and make sure everything looks fine there, and then that may be the end of this.
I sure appreciate it.
Okay.
We weren't trying to be abrasive at all. We were just trying to protect our rights, man. That's all.
I understand that, and which is why I granted you the right to appear at this hearing before I made any decision about it. So,
yes, ma'am.
Okay, then, Mr. Albee, if you want to get an order over to me, I'll sign that. We'll get the bridge interview set up as soon as possible so that, we can get this done and move on.
Thank you, Judge.
Okay. All right. Thank you all very much. I appreciate it.
Do you know, I don't know, I don't know. Do you know when this is supposed to occur, Your Honor?
They'll get an order to me probably this afternoon. I'll sign it, and then I don't know when the bridge interview will be scheduled, but they'll contact you about it. Ms. Hooks will.
Okay, man. I thank you for your time, and I'm sorry if I wasn't trying to be